mundo y bienvenido a mi canal. Yo me llamo Sirey. Soy una abogada afro-latina licenciada practicando la ley criminal, pero como todos ustedes, a mí me fascina cuando estamos hablando de casos de crímenes reales. En este video vamos a continuar nuestra conversación de Barry Morphew. Si quieren más video en español, nada más dime allá abajo. Hi everyone and welcome back to my channel. My name is Desiree. I'm a licensed and practicing Afro-Latina criminal attorney who, much like the rest of you, has a severe fascination with true crime cases. Listen, you guys, like I told you guys in the last video, I wanted to make sure that I relay the facts to the best of my ability here, as well as go through the documents to the best of my ability. This is going to be the second part of our multi-part saga on Barry Lee Morphew. When we last left off, we were talking about all the different twists and turns that Barry Lee Morphew's case took, and just talking about specifically his arrest affidavit and the surprise that came directly after. Now that we're here, let me tell you what happened. 9 days before Barry Lee Morphew was set to stand trial, and on April 19th of 2022, the prosecution in this case, specifically the named prosecutor for the 11th Judicial District for the state of Colorado, Linda Stanley, files a motion to dismiss all charges against Mr. Morphew without prejudice.
Nearly an entire year after he was arrested, Barry Morphew is clear of first-degree murder charges. Just over a week before the trial was slated to start, the prosecution does have the right to refile those charges if they ever feel confident enough in their evidence.
I was trying to find the motion that precipitated this motion, but I was unable to. It's my understanding, throughout all of the pretrial motions that were filed in this case, the defense attorneys in this case were able to successfully convince the court to grant a motion to suppress and actually exclude some of the evidence and some of the testimony and witnesses against Mr. Morphew. Following exclusion of its evidence, the prosecutors filed this motion, and let's get into it, shall we? Again, as you guys can see, the case is captioned State of Colorado versus Barry Lee Morphew, defendant Linda Stanley, who is the named district attorney for the 11th Judicial District of Colorado. It says her license number, which is 45298. It also lists the address for the courthouse. Then it says, the people by and through Linda Stanley, District Attorney for the 11th Judicial District, hereby move this court to dismiss the charges against the defendant in 22 CR 47 without prejudice. I'm going to stop right here because I know we've talked about this numerous times, but I love being your broken record. Without prejudice means that the prosecution can refile the case at any point that they choose. A dismissal with prejudice means that the prosecution is acquiescing and saying that no other charges, at least stemming from these facts, will be refiled against this defendant. So I say that to say, a dismissal without prejudice really isn't much to celebrate about. Specifically, when we get into the text of this motion right here, and you see exactly what they're saying in it, I'm wondering if Mr. Morphew's attorneys just didn't properly advise him, or if his expectations were just wrong. But let's carry on. On May 6th of 2021, the defendant was brought before the court on charges including the first-degree murder of his wife, Suzanne Morphew. To date, Ms. Morphew's remains have not been found. On September 17th of 2021, after the Honorable Judge Murphy found probable cause for the charges listed in the indictment, but declined to find proof evident presumption great, the defendant was granted a bond that was quickly posted. The same day, the defense entered a formal plea of not guilty and agreed to toll speedy trial to accommodate a trial date slated to begin on May 3rd, 2022. In subsequent filings, the court added an extra few days of trial in anticipation of a more extensive jury selection period. Trial is now scheduled to begin on April 28th of 2022. Throughout the pendency of this case, the people in law enforcement have been unrelenting in our search for Miss Morphew. For some time, a single location has been the target of ongoing investigation. For the reasons expressed below, the people have a good faith reason to believe further investigation into this matter is essential to answering the most consequential question presented by this case. As this search cannot be accomplished in the coming weeks due to weather and snowpack conditions, the people respectfully ask this court to dismiss the current indictment against the defendant without prejudice. As an offer of proof, the people and law enforcement believe we are close to discovering the victim's body. The people were hopeful that the search for and the discovery of the victim's body would be concluded well before trial, but weather has complicated the efforts. Specifically, the area law enforcement has been focused on is a remote and mountainous region nearby the Morphew residence. This area received a significant amount of snow over the winter months before a search could be completed. To date, the area has 5 feet of snow concealing the location where the people believe Miss Morphew is located. As a result, the people cannot safely excavate this area and resolve this unanswered question. By filing this motion, the people have complied with Rule 48A, a motion to dismiss submitted in writing, publicly available, proffered in open court, and accompanied by a statement summarizing the reasons for this action. Given the timing of this motion before trial, the defense does not need to consent and does not have standing to object. The court need only resolve the question of whether or not this motion was filed in good faith, such that clear and convincing reasons exist, which further the interests of justice for the public and the defendant. Issues related to speedy trial or any other outstanding litigation would not be relevant to the court's determination at this juncture. Here, the people have presented sufficiently reliable good faith reasons to dismiss without prejudice. First, the people believe that we are close to locating the deceased victim's body. The people's fundamental responsibility in the criminal justice system is not to gain a conviction, but to further the truth-seeking process and ensure equal justice. In typical homicide cases, the fact of the victim's death is rarely at issue, but in a case such as this, the most influential fact of consequence is whether or not Miss Morphew is deceased. If the body proves to be there, further forensic examination could potentially inculpate or exculpate the defendant, which is incredibly important evidence for the jury to hear in determining the merits of this case. Given the need to conduct further investigation to resolve these issues, there is a good faith basis to dismiss the current indictment. Second, when this case was filed, it was mainly premised on the defendant's motive to harm the victim, his sole access to the victim at the exact time she was communicating with anyone by phone, and his constant dishonesty with law enforcement, which came to light given the truck telematics, phone, and location data recovered. The court functionally excluded the people's best evidence to move forward in this case by severely limiting our experts' testimony. Even if the court were to partially reconsider its position on the need for such severe sanctions at this late hour, the people would still be left without several key expert witnesses initially endorsed. Without this crucial evidence and without the victim's body, the people cannot move forward at this time in good faith. Ethics demand that prosecutors proceed to trial only in circumstances where a reasonable likelihood of success exists, which, given the court's current rulings and the uncertainty of any further rulings, is impossible to completely ascertain. This assessment of the remaining evidence is an additional good faith basis for this motion to dismiss without prejudice. So I'm going to simplify that for you guys as best as I know how. Basically, what the prosecution is saying is, well, Judge, because the court really limited what we can introduce as evidence, you severely limited the testimony of our expert witnesses. You severely limited what witnesses we can call. We can't proceed here without her body at this point because what evidence do we have, Your Honor, is basically what they're saying. But if you listen to me read through everything I just read to you right now, in my mind, and I don't think it takes a trained attorney to decipher this, it was very evident that they're like, listen, we're going to put this case on pause. So we'll dismiss it right now without prejudice, this current indictment. But okay, let us find that body and it's going to be up. That's basically what it sounded like to me. So Barry's actions after this were rather interesting. So exactly 1 year following dismissal of these charges, Barry Lee Morphew filed a civil lawsuit seeking $15 million in damages against the district attorney's office, all law enforcement involved, all law enforcement agencies involved, claiming that he was the victim of malicious prosecution.
For your news at 10 o'clock, Barry Morphew, the Chaffee County man accused of murdering his wife nearly 3 years ago, is striking back, filing a federal lawsuit for a hefty sum of cash.
He accuses both state and federal law enforcement of, quote, maliciously prosecuting him when they knew he didn't do it. Investigative reporter Sean Rice joins us live in studio to break down the suit filed earlier today. Sean?
Yeah, Bert and Heather, Barry Morphew is asking a federal court to award him $15 million after being, quote, repeatedly wrongfully accused of murdering his wife, Suzanne. His attorneys allege the FBI, CBI, and District Attorney Linda Stanley's office withheld key pieces of evidence while prosecuting him, causing him and his two daughters serious emotional distress.
Barry even went on to do multiple interviews, proclaiming his innocence and his devastation for even being considered a suspect in his wife's disappearance.
Now Barry and his daughters Macy and Mallory are speaking exclusively to ABC News, claiming his life has been ruined by false accusations.
What have these last 3 years been like for you?
Very, very sad. Very confusing. Just so traumatic. Like, literally, our worst nightmare.
Did you have anything to do with the disappearance of your wife?
Absolutely not. It's very hurtful to lose your reputation and your integrity.
Barry filing a $15 million civil suit against prosecutors, the sheriff, and several investigators.
So I know that 15 million is a huge number, but I don't think that, in my mind, that covers any of the damage that's happened to Barry and the girls.
They know he's innocent. And if they would just look for Suzanne outside of where they hypothesized Barry could have possibly buried her remains, they could find her.
His daughters standing by him.
You never had a shred of doubt once you heard the evidence from law enforcement against your dad?
I've never had a shred of doubt. Not one.
And I apologize, nothing in this is funny, but for Barry's audacity, I guess. Did you read the motion? They said, for the time being, right now, currently, while we're still searching for this body, the charges will be dismissed against this defendant. It didn't say that you weren't the person that they were searching for. It didn't say that they found alternative suspects that they might want to consider. All it said was, we need the body. And then you still decided to file a suit for malicious prosecution? My mom, or le voy a decir en español, ok, te lo voy a decir en español. Mi mamá siempre le gusta decir que se acabó la fiesta. Se acabó la fiesta. And that's basically exactly what happened to Mr. Morphew here. Because after filing his lawsuit, a judge dismissed it, saying, sure, the prosecution shouldn't have filed charges against you because they couldn't prove them beyond a reasonable doubt. But law enforcement still had a reason to issue an arrest warrant for your arrest, and you were rightfully arrested. There was enough probable cause for this. What would you like me to do?
Morphew had filed a civil case related to what he called a malicious prosecution, was asking for $15 million in damages. Morphew was arrested for murder in connection to his wife Suzanne's disappearance, but then those charges were dismissed in April of 2022. Morphew filed a civil case against Chaffee County prosecutors, the Colorado Bureau of Investigation employees, and the FBI employees. While the judge had agreed with Morphew on a couple of points, including that it should be easier to sue for a mishandled prosecution, the judge ultimately said that he had to apply the law as is currently written and had to dismiss that claim.
Okay, and while we're talking about ridiculousness that has happened in this case, I have said the name to you, Linda Stanley, no less than 2 or 3 times throughout the coverage of this case. And I kept saying it because I wanted you to remember that name. So, the elected district attorney for the 11th Judicial District, some point following dismissal of the case, was disbarred by the Colorado Supreme Court Following a disciplinary hearing, a hearing board majority disbarred Linda Stanley, attorney registration number 45298. Though the disbarment would ordinarily take effect on October 15th of 2024, the actual effective date may be later by operation of CRCP 242.35. Following a Chaffee County woman's highly publicized disappearance, Stanley, who was the newly elected district attorney of Colorado's 11th Judicial District, brought first-degree murder charges against the woman's spouse. During the prosecution, Stanley made 3 improper extrajudicial statements about the case in the media. These statements threatened to prejudice the defendant and undermine the public's interest in justice, and contributed in part to a judicial ruling changing venue in this case. Through this misconduct, Stanley violated Colorado Rule of Professional Conduct 3.6a. A lawyer who participates in the investigation or litigation of a matter must not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding. And Colorado Rule of Professional Conduct 3.8f. Prosecutors must refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused unless the comments serve a legitimate law enforcement purpose, are necessary to inform the public of the nature and the extent of the prosecutor's action, or are permitted under Colorado Rule of Professional Conduct 3.6b. At the same time, Stanley did not adequately supervise the prosecution of the case. She failed to timely direct adequate administrative resources to process discovery, leading to a series of judicially imposed sanctions against the prosecution for discovery violations. She failed to take reasonable measures to establish a leadership structure that ensured accountability within the prosecution team, with the result that the prosecution team overlooked important projects in the case. And she failed to intervene when the prosecution team was given an opportunity to cure its deficient endorsements for expert witnesses, the majority of whom were eventually excluded. Through this conduct, Stanley violated Colorado Rule of Professional Conduct 5.1b. A lawyer with direct supervisory authority over another lawyer must make reasonable efforts to ensure the other lawyer conforms to the rules of professional conduct. After the presiding judge issued several adverse rulings less than 2 months before jury selection, Stanley instructed her chief investigator to interview the judge's former spouse to determine whether the judge committed domestic abuse. Even though she had no credible evidence to believe that the judge had ever engaged in such criminal conduct, Stanley ordered the investigation in an effort to uncover information about the judge that would require him to recuse himself from the case. Shortly after the interview, which revealed that the judge had never abused his former spouse, Stanley dismissed the case without prejudice. Through this conduct, Stanley attempted to violate Colorado Rule of Professional Conduct 8.4d. It is professional misconduct for a lawyer to engage in conduct prejudicial to the administration of justice, thereby contravening Colorado Rule of Professional Conduct 8.4a. It is professional misconduct for a lawyer to attempt to violate the rules of professional conduct. In a bid to rehabilitate her relationship with the media, Stanley later agreed to sit for a videotaped interview with a local reporter. During that interview, which Stanley reasonably should have known was on the record and would be publicly disseminated, she again made improper extrajudicial statements about 2 defendants criminally charged in the death of a 10-month-old baby. She effectively pronounced that one of the defendants was guilty, revealed inadmissible details about the defendant's sexually based juvenile offenses, and impugned the motives and character of the defendants. 2 judicial officers, ruling independently, concluded that Stanley's extrajudicial statements amounted to outrageous government conduct so severely prejudicing the defendants that judiciary was required to dismiss each defendant's criminal case. Through this conduct, Stanley again violated Colorado Rule of Professional Conduct 3.6a and Colorado Rule of Professional Conduct 3.8f. What I find extraordinarily fascinating about Linda Stanley's disbarment is that prior to becoming the newly elected 11th Judicial District Attorney, she was publicly censured. In February of 2017, Stanley agreed to represent a client in a civil case. 8 days after she executed the engagement letter, Stanley accepted employment as a hearing officer for the Colorado Department of Revenue. She began working for the state 10 days after, but Stanley did not advise the client that she left private practice. Instead, Stanley sent the client a past due invoice assessing late fees. When the client learned of Stanley's new position in April 2017 from a third party, the client asked Stanley about her new employee. Stanley merely replied that the client owed fees and stated that she would find substitute counsel. When the client had not paid the invoice by April 30th, Stanley threatened to send his account to collections and told the client that she could not, in good faith, refer his case to another lawyer. In June 2017, Stanley's client expressed concerns to the court about Stanley's representation. By this time, a 3-day jury trial had been set in this case. The next month, Stanley attempted to withdraw from the client's case, but her filing was rejected due to errors in the caption and an improper form. She tried that same month to file another motion to withdraw, but that motion too was rejected, this time because she had filed it in the wrong court. She did not successfully file a motion to withdraw until August of 2017. As of August 2017, Stanley had not given the client actual notice of her intent to withdraw. The client filed a pro se motion to terminate her representation, and the court set a hearing on the motion for October 2nd of 2017. Stanley failed to appear, however, so the court ordered her personally to appear at a hearing set for late October 2017. Before that hearing, Stanley filed a response to the court's order in which she revealed numerous client confidences. 3 days before the hearing, the court considered Stanley's response and granted her motion to withdraw. Through her conduct, Stanley violated Colorado Rule of Professional Conduct 1.3. A lawyer shall act with reasonable diligence and promptness when representing a client. Colorado Rule of Professional Conduct 1.4a3. A lawyer shall keep a client reasonably informed about the status of the matter. Colorado Rule of Professional Conduct 1.6a. A lawyer shall not reveal information regarding the representation of a client unless the client gives informed consent. And Colorado Rule of Professional Conduct 1.16d. A lawyer shall protect a client's interests upon termination of the representation, including by giving reasonable notice to the client. Man, that was a lot for me to unpack with you guys. And I know I'm taking my sweet and precious time on this case, but I'm doing that for a reason. Let's talk about what happened next in Barry Morphew's case in my next video. As always, thank you guys so much for watching. Please be sure to like, comment, share, and subscribe. Until next time, y'all take care.